You know what I'm talking about. That huge wall of text, the terms and conditions, the dreaded fine print. We've all seen it. But have you ever actually wondered if you can fight it? Well, today, we're pulling back the curtain on exactly what these clauses are and the insane legal gauntlet they have to survive to even be valid. Let's get right into it. Come on, be honest with me. You're downloading some new app or you're buying a concert ticket and boom, there it is, that little box. You scroll like a maniac to the bottom, you click I agree, and you move on with your life. We all do it. But what in the world did we just agree to? And can those sneaky terms buried in paragraph 72 really come back to bite us? So, in the legal world, there's a name for this stuff. It's called an exemption clause. And its one and only job is to say, hey, if something goes wrong, it's not our fault. Or maybe, okay, maybe it is our fault, but we're only going to pay you a tiny, tiny amount. It's basically how a company tries to cover its own back. But you know what? The law has a lot to say about that. And here's where it gets really interesting. Courts don't just take these clauses at face value. Actually, it's the opposite. They're incredibly suspicious of them. For an exemption clause to be seen as fair and legal, it has to run what I like to call a judicial gauntlet. It's like a tough two-stage hurdle race, and it's specifically designed to weed out the unfair ones. So here are the two big hurdles in this race. Hurdle number one is incorporation. The first question is, was the clause even properly included in the contract in the first place? And if it clears that, it faces hurdle number two, construction. This is where we look at the exact words and ask, does this clause actually cover the specific thing that went wrong? A clause has to clear both of these hurdles. If it fails either one, it's out. So let's break down that first hurdle, incorporation. How does a company even get one of these clauses into a contract? You can think of this as the qualifying round. If it doesn't pass this, it doesn't even get to compete in the main event.
Okay, the most powerful, most bulletproof way to get a clause into a contract is with your signature. The general rule, and it's a pretty harsh one, comes from a classic case called Lestrange. It basically says, if you sign it, you are bound by it. It does not matter if you didn't read it, didn't understand it, or the print was microscopic. You signed it. But, and this is a huge but, there's a critical escape hatch from another case called Curtis. If someone actively lied to you or misrepresented what you were signing, then your signature might not count for anything.
Let me tell you about that Lestrange case, because it's a wild one. A woman bought a cigarette vending machine for her cafe. It didn't work. Turns out she'd signed a sales agreement that had a clause, in teeny tiny print, saying all warranties were excluded. The court pretty much said, too bad. Your signature is ironclad proof you agreed to everything in that document, even the parts you never saw. Ouch! Now let's flip that coin and look at the Curtis case. A woman took her beautiful wedding dress to get cleaned. The shop assistant hands her a piece of paper to sign. She asks, what's this for? And the assistant says, oh, it just means we're not responsible for any damage to the beads and sequins. Well, that wasn't true. The clause actually said they weren't responsible for any damage whatsoever. When the dress came back with a big stain, the cleaners pointed to the signed document. But the court said, nope, because they had lied about what it meant, the clause was completely invalid. Okay, but let's be real. Most of the time, we aren't signing a physical piece of paper. What about the terms on the back of a ticket or a sign on a wall at a car park? How did those become part of the deal? Right, so this is called incorporation by notice, and the rules are super strict. First off, timing is everything. You have to be made aware of the terms before or at the exact moment you make the deal. There was this famous case where a notice on the back of a hotel room door didn't count because the contract was made when the guest checked in at the front desk downstairs. By the time they saw the sign, it was too late. Second, the notice has to be in something that a reasonable person would think is a contract. For instance, a ticket for a deck chair on the beach. A court decided that's just a receipt, a proof of payment. You wouldn't expect to find legally binding terms on it. And this all leads to one of my favorite legal ideas ever. If a company wants to sneak in a really nasty or surprising clause, they can't just bury it in the fine print. They have to do something really dramatic to draw your attention to it. The legendary Judge Lord Denning famously said that for some clauses to be valid, they'd need to be printed in red ink with a red hand pointing to it. I love that. Basically, the crazier the clause, the louder they have to shout about it. All right, so let's imagine a clause clears that first hurdle. It was signed, or the notice was given at the right time. It's officially in the contract. But the race isn't over yet. Now it has to face the second hurdle. And frankly, this one is often even tougher. It's called construction. This is where the court puts on its glasses and dissects the exact wording to figure out what it really means. And the court has a secret weapon here. It's a principle with a very fancy Latin name, contra proferentum. Don't worry about the name. All it means is that if a clause is vague or confusing or could be read in two different ways, the court will always choose the meaning that goes against the person who wrote it. So if there's any doubt about what the words mean, that doubt works in your favor. The burden is on them to be crystal clear. Now, courts get especially tough when a company tries to get out of trouble for its own carelessness, what lawyers call negligence. To do that, the clause has to survive something called the Canada Steamship Test. It's a 3-step checklist. First, does the clause actually use the word negligence? If it does, okay, it passes. If not, step 2, are the words super broad, like any loss whatsoever? And if they are, here's the really clever part, step 3. Could those broad words possibly apply to some other kind of legal problem besides negligence? If the answer is yes, the court will say the clause only covers that other thing and doesn't protect them from their own negligence. It's a brilliant way to narrow the clause's power right down. So the clause is in the contract. The wording seems to pass the tests. But what about the ultimate challenge, the final boss, if you will? What happens if the failure is so massive, so total, that it completely destroys the entire point of the contract? Yeah, this is the idea of a fundamental breach. We're talking a complete and utter failure to do the one thing you were hired to do. Can an exemption clause really protect someone when that happens? I mean, seriously, can a contract let you deliver a box of rocks instead of a diamond and just say, whoops, not our problem? You have got to hear about the unbelievable case of photo production versus Securicor. So, a company hires Securicor to provide security guards for their factory. Simple enough. One night, the security guard on duty decides to, start a small fire to keep himself warm, and he ends up burning the entire factory to the ground. I am not making this up. That is about as fundamental a breach of a contract to provide security as you can possibly get, right? Now, Securicor's contract had this super broad, super clear clause saying they weren't liable for what their employees did. You'd think, no way, a court would never let them get away with that. But they did. The highest court in the land looked at it and said that because this was a deal between two businesses who both knew what they were doing, they were perfectly free to decide who should bear the risk. The clause was written in plain English, it was totally unambiguous, so it stood up, even for burning the whole place down. Wow. Whew. So after running that entire crazy legal gauntlet, where does that leave us? What are the big lessons here? What does this actually mean for you? Let's do a super quick highlight reel of those key cases. Lestrange teaches us that your signature is incredibly powerful, but Curtis is the counterpunch, showing that a lie can break that power. Ollie and Shackleton are all about the timing and the packaging. The notice has to be upfront and look official. And finally, the wild case of photo production shows that when businesses make a deal, courts will let them decide the rules as long as they write them down clearly. So if you remember nothing else, remember this. 1. Courts do not just blindly accept fine print. They really put it under a microscope. 2. A signature is a big deal unless someone tricked you into signing. 3. For any other kind of notice, when and where you see it is everything. And 4, my favorite, if the wording is confusing, that confusion is the other side's problem, not yours. It all goes to show that the legal system actually has a framework designed to protect us and create some level of fairness. At the end of the day, the law gives you way more protection than you might think. It proves that even in the cut and dry world of contracts, that fine print has to play by the rules of clarity and fairness. So the next time you see that I agree button staring back at you, what's the first thing you're going to look for?